Hi everyone, very good afternoon to you again, to all our attendees. Now I do see some of you all very regular with us. Thanks for joining us in today's our MIS lunchtime webinar itself. Today is our 12th day, in fact, 12 sessions on our MIS lunchtime webinar. So as you all know, I think if you have been following us on our lunchtime webinar, we've actually extended our lunchtime webinar to perhaps like what we said till the end of the lockdown period or the circuit breaker period. Okay, so today we have someone very interesting, right? That he's a very well-known lawyer. So I'll be telling you more about that. Now, if you have actually missed out on any of our talk during this episode, our lunchtime webinar talk itself, you can always find us on Facebook or on our YouTube channel. So log on to our MIS Facebook. All right. Can I have the slides, please? Okay. Now, just find us on Facebook, Marketing Institute of Singapore, and log on to our Facebook and then like us from there. Okay. Now you can also share and our Facebook page itself. Now we hope that you can actually do that on our behalf. All right, share it with more people so that more people like you will be able to benefit from our lunchtime webinar. Okay, so as we would like to reach out to more people and to get connected with them, especially the global professional bodies out there. Now, you can always benefit from our lunchtime webinar, where we touch on relevant topics that will actually help you in your work, in your profession. Okay, like what we said today, in fact, we're very glad to actually have a well-known lawyer, Mr. Samuel Sell, to be with us, and he'll be touching on the legal essentials for startup. Okay, now, which is most important, especially when you're going into a new business venture, and knowing the legal framework will be most important. I think a lot of startup out there, in fact, they neglected this aspect of their business, and which are some very important points. And along the way, sometimes they make some blunders for not engaging legal services, which is most important to manage the issues for their new startup. Okay. Now, respective rights and duties must be framed right from the start to actually prevent potential hazards that day. So knowing the proper strategy and to understand the fundamentals of the legal structure, especially when it comes to founders agreement, legal protection for intellectual property, and the importance of contract, it's important, especially for startup and for future business improvement. So MIS itself, I think by now you should know we are actually a not-for-profit body itself, and our MIS Business School is also a charity body. Now we are a premium provider. Now, as you can see, Samuel is also our trainer in our executive program. So do join us. MIS value towards the community will be to offer our executive development courses across 9 disciplines. So currently we have got more than 120 of such courses, which stretches of between 1 to 4 days. Okay, so do find out on our courses on the 9 major disciplines. Samuel, it's also one of our newly acquired trainer, and we're certainly very glad to actually have him to join us. Okay, MIS, we have been voted, like what we said, over the past 5 years as the top trainer, top corporate training provider in Singapore itself. So that really speaks volume on the kind of courses that we offered to our members. Now, of course, we do not just look at the executive training program. We do have our academic program. Okay, so MIS, a lot of them, from time to time, so during some of our networking sessions itself, they always say that, hey, MIS, we know you as an institution that offers your diploma. Yes, we do. Okay, and in fact, I'm very glad to actually share with all of you that we do have our advanced diploma. Sorry, can I have the previous screen? Thank you. Okay, our advanced diploma in digital marketing, which is something that is new, and at the same time, in this age itself, if you do not arm yourself with sufficient digital marketing skills, you will be obsolete. Okay, all right, and of course, not forgetting our diploma in sales and marketing, which is our diploma in sales and marketing has been with us for more than 20 over years. We have a lot of us graduates under our alumni, which are very, very well known business owners and entrepreneurs. So perhaps you would like to check out on our diploma in sales and marketing, and of course our diploma in business. Okay. Now, if you were to see on the slides itself, it's open for registration now. Just reach out to us at the telephone number, or otherwise you can always look out for us on our web page, on our website, and on our Facebook. Okay, right, which will bring me to our next slide. Now, a lot of them have actually asked me, hey, Roger, can you give me some form of discount for all these courses? Certainly. All right. You can always join us as a member or as an associate member itself. And as our member, you are able to enjoy our EDS, our executive development courses, up to about 20% discount on the courses. Okay. And on top of that, you will be able to enjoy a lot of value-added services that the Marketing Institute of Singapore is providing to the community. Now, as for now, in fact, we are giving away our associate membership for you free of charge in support for Stay Home SG. All right, so if you would like to find out how can you get hold of the free membership during this period of time, do look out for the telephone number out there where you can contact Ms. Judy Ko or Ms. Ego Chang, where they will be able to tell you more about our associate members. Okay, and for those who are not in Singapore, no worries. Okay, we do have an avenue for you to apply as our international associate members. So you can always send us an email on how you can get hold of our international associate members. Right, next. Now, as you know, we are a not-for-profit body, and we also do CSR, corporate social responsibility. Here's where we have our mass donation. I think you've been hearing me talking about this over the past 10 days, okay? So MIS, we are doing our very bit in terms of CSR, not for Singaporean, so sorry to say, but because in Singapore, we are very well taken care by our government, and we are all equipped with masks provided by our government. And of course, it's also quite easy for you to get hold of a box of masks. You can just head out to the supermarket right now while you're doing your daily groceries, and you can always pick up. But I couldn't say much of our peers in Philippines, in Indonesia, in Bangladesh. Okay, so therefore we are actually doing our mass donation. Okay, so you can help us by joining us in this mass donation where we are working with the Philippine Marketing Association and Ms. Gwen, our immediate past president of the Asian Marketing Federation itself, who is in Philippines right now to help us to distribute the masks to the general communities in Philippines. Now, as you know, it can be quite a dire situation for you not even to have the basic mask to protect yourself from the COVID-19 virus. So do help us. It's well, we're just looking at donation of per person per box, $20. Okay, this is the price that we're getting from our supplier. So if you may, $20 will really go a long way in helping 50 people because there are 50 masks in a box. So just a mere $20, you'll be able to help a lot, in terms of the communities beyond Singapore, our ASEAN community. Okay, so likewise, there are 2 telephone numbers over there. Please call them, WhatsApp them if you would like to join us in our donation drive. Just a mere $20 per box. I think you certainly can do better than that. Okay, right, go on. Next. Now, as you know, MIS, we are doing our bit in terms of lunchtime webinar. We've been doing this for the past 11 days. Today is our 12th session. And our second series in terms of our webinar, as you can see, it's live. Please help us to actually post it on your YouTube also. Yesterday, we have our first speaker of for our second series, that's Ms. Gil Lee. And today, our second speaker for this series will be Samuel Sell, which will be touching on the legal essentials for startup. All right, and you can see the suite of speakers that are coming forth. Okay, so please stay on with us for the rest of the week, and then join us, especially during your lunchtime. Okay, right. Next. Now, Samuel is a close friend. I think I knew him for quite a while, and he always come across as someone that's very, very, very passionate in the thing that he does. Okay, all right. And Samuel is a legal expert in the field of intellectual property law, media law, and general commercial and corporate law itself. He has extensive experience in dealing with a wide range of transactions, with a special focus on the applications of these laws to the entertainment, arts, and media industries. Okay. Apart from being a lawyer, he's also an acclaimed speaker on topics relating to all aspects of law and entrepreneurship. And Samuel has been invited to speak at many events throughout the world, including our Singapore first TEDx event ever held in Singapore itself, and the X Media Labs events across Australia. So in 2010, Samuel backed home the Spirit of Enterprise Award that recognizes the entrepreneurial spirit in Singapore. And of course, just to name a few, that's all. He has got many accolades under his name. Okay, so without further ado, let's welcome Samuel into our room. Hi, Samuel.
Hello.
Hi, Samuel. Hi, nice to have you, Samuel. We would really like to thank you. You know, despite of your very busy schedule, I know you're still handling a lot of cases and giving out a lot of legal advice. You know, to even to the committee. Sometimes I know from time to time you do give out free legal advice, and based on the situation that some of them are in right now. And in fact, you're doing a lot of charity work right now in helping the needies, and especially some of the startup. Okay, and I think at this period of time where it's most crucial, where we are seeing a lot of companies facing financial crisis, having to take up legal actions or mitigation actions itself. And here is where I know, Samuel, you have been offering a lot of advice to them. And on behalf of the community, the business community, and the entrepreneurial community itself, I would like to give you a word of thanks. And really would like to applaud you for all your work in terms of helping the business community. Okay, so without further ado, I know you guys are not you're not here to listen to me. You're here to actually listen to our most acclaimed speakers. Now, if you can, after these sessions, go to TEDx. I think where Samuel actually touches on happiness, and yeah, this is one of the TEDx talks in Singapore itself that I've viewed a couple of times, in fact. So yeah, please look out for Samuel on TEDx talk also. Like what I said, Samuel is our newly acquired trainer in Marketing Institute of Singapore. He will be touching on a series of law courses coming up. So, right. So, Samuel, take it on. All right. Welcome.
Thank you so much. Okay, so today I will do this for the first time. I have never done sharing of screens before, but I'm going to now try to do it. Can you all see it?
Yes, we can. We can see your screen.
Sure. Okay, can you see my screen now? Okay, great. So today we're going to talk a bit about the legal essentials for startups. A lot of startups, as Roger said just now, when they start to do their business and they want to enter into a new kind of business to disrupt the situation that we have now. Some work, but many startups actually don't work. And I think one of the reasons why startups actually don't work sometimes is because a lot of these administrative and legal niceties are not actually complied with. So today, I'm not going to be able to make you an expert in all these legal issues in 45 minutes, but I'll certainly try to give you a brief taste of what actually needs to be done so that you all don't get into trouble. Okay, so the first thing that you need to do when you want to maybe set up a business is to think of, okay, there's so many types of business entities, okay? So we have sole proprietorships, we have partnerships, we have private limited companies, we have limited companies, we have LLPs, we have LPs. What exactly are these entities and how are they all different? Because when you choose one entity, it will have an impact on whether you yourself can be sued or not, and it will have an impact on how you get money and how you pay your taxes. So today, we first start off with the different types of entities that we have. Of course, there are some other entities that I won't be talking about, but these are the more familiar ones that generally people use. So the first type of entity that people use when they set up a business, and they usually do this because they think it's very cheap. So like I go online and I just set up a business now. So I set up a business and I pay $30, $60 to set up a sole proprietorship. So a sole proprietorship, if you sole means one person, solo, right? So if you're just one person and you want to set up a business, so you will do it as a sole proprietorship. But what happens when you have a sole proprietorship generally is this. So for example, if I'm setting up a company, if I'm setting up a business selling lamps or lights, then I just call it sole proprietorship lights, for example. So if I call it SP lights and I hold on to basically the SP lights name, essentially it is still me. So if anything happens to the lights, I have so many lights around me now because my lighting was quite bad. But one of the lights, let's say if someone sold me a light and it blew up and it caused a lot of damage to my house. So what happens in that case is, if I were the person who bought the lights, I would be able to sue the person who sold me the lights for the liabilities that have arisen as a result of him selling me a defective light that caused me so much damage. So what do? I will sue the sole proprietorship. But when I sue the sole proprietorship, who essentially am I suing? I'm not suing SP Lights. I'm suing the person under SP Lights, who would then have to go and find money to pay me. In Singapore, we have this eggshell skull rule. So for example, if the lights generally wouldn't affect a person very badly, but if the light blowing up actually caused death, then in that situation, I think you would be even in more dire need of making sure that there was some kind of protection against personal liability. Because personal liability would mean that if you don't have like the tens of thousands or the hundreds of thousands to be able to pay this person for death or damage or injury, then you would have to go and find the money to be able to do it. Otherwise, you could become bankrupt. So sole proprietorships are dangerous in that they are unlimited liability to the person who owns the business. So unlimited liability is a big, big no-no for sole proprietorships. Now, when you are not sole and you have other people who are working with you in the business, then the business would be, if you were going for these kinds of like this level of business, it would be called a partnership. So for example, if I have a partner in the SP Lights business, and then the partner was the one who actually bought these lights from China, and these lights are now defective, and he was the one who was negligent because he didn't do his due diligence, and things got really bad, and then they blew up in a customer's face. So what happens? Let's say my partner is a person called Edgar. If Edgar is the person who actually went to defectively purchase these lights, which caused a lot of damage to the customer, then what happens? Would I, who had entirely nothing to do with the purchase of the lights and I was not negligent at all, would I be the person who would somehow be liable, even though Edgar was the person who bought the lights? What do you think? So if you think that somehow I will be shielded from liability because it wasn't my fault, it was totally Edgar's fault, then in these kinds of situations, you really shouldn't have the partnership model of doing business. Because in a partnership, what happens is each partner is jointly and severally liable for the debts and obligations of the business. So I'll say that one more time. Each partner is jointly and severally liable for the debts and obligations of the business, which means even if Edgar was the one who went to become negligent and I had nothing to do with it, if Edgar runs away, because this partnership also has my name in it, I will be jointly and severally liable, meaning I will be the person who would still have to meet up with these obligations, even though my errand partner had run away. So they don't have the choice of saying, okay, I will only have to sue Edgar. No, they can't do that because it's a partnership. So I'm jointly and severally liable. If Edgar runs away, there's damage caused to them. They can also come and attack me. So that is why partnerships are really, really scary. And my personal viewpoint is perhaps not a very good idea to enter into sole proprietorships and partnerships, which is why the law has come up with different types of doing business. Sole proprietorships and partnerships are as easy peasy as they come. I mean, you just go and spend $30, $60, and you can even now even register a business online. But yes, you can register a business online to do business, but does it actually give you any liability coverage to make sure that you don't get personally liable? Then if they don't have that particular trait, you may not want to use the sole proprietorship and partnership model, which is why the law comes up with two other types of partnership models. Because when you are a plain partnership, you are jointly and severally liable. I'm going to say this many, many times until it gets drilled into your head. You are jointly and severally liable for the debts and obligations of your partnership. But the law comes up with two different other types of partnership. So one type of partnership, which is new, is called the limited partnership model. So a limited partnership model means this. Let's say Edgar and I have set up SP Lights together. But because Edgar is a person with a lot of money and I really have nothing but just like a pair of hands and able to like work. So if Edgar is the investor and he invests into SP Lights, I can enter into this limited partnership with him where he becomes nothing but the investing partner and I become the general partner. The general partner means a person who is responsible for anything that happens within the partnership. That means any debts and obligations, I will be the one who will be solely liable, but the person who is the limited partner, who is usually the investing partner, will not be liable if anything happens. So in this way, what happens is the limited partnership model actually already says that the investing partner or the limited partner will not be responsible if anything happens. It is all the pasal of the person who is the general partner. So the general partner would be the person who would have to bear all the debts and liabilities of the company, which is very different from the partnership model. The good thing about the limited partnership model is it makes the investor covered against any kind of liability. But the general partner then basically quite tough now. If anything happens, the general partner is the person who has to face the music for everything that happens. Okay, which is why then we have another model, which I think is more popular in Singapore, called the Limited Liability Partnership, or the LLP. So the Limited Liability Partnership model is once again different from the partnership and the limited partnership model. So the Limited Liability Partnership model goes like this. If we go into an LLP together, if anyone sues the LLP as SP Lighting LLP, if any, I hope there's no company actually with that name, but if there was SP LLP, SP Lighting LLP, which is the limited liability partnership, if some light blows up in someone's face and causes a lot of damage to that person, the LLP is a separate entity from its partners. Meaning in law, when you set up an LLP, the LLP is a new person under law that can be sued, which means the two of the partners under the LLP may or may not be personally liable for the debts and obligations of the LLP. So in this situation, where the lights blow up in someone's face, the LLP will be the person whom the person whose face has been blown up will have to sue. Okay, but they will sue the LLP. But the difference between an LLP and a private limited, which we'll talk about later, is that the LLP only gives a partial shield to the persons within the partnership. So the partial shield means this: you can sue the LLP, but the LLP has no money. You can also sue the partner who was responsible for incurring this loss. Which means if I was the innocent partner and Edgar was that partner who had been negligent, not only can they sue the LLP, they can also sue Edgar. But the person who is limited in liability is me, the person who was not responsible for causing this loss. So remember, the LLP gives a partial shield, and it shields the partners who are not responsible for incurring that loss or that obligation. So that's the difference between the LLP, the LP, and the partnership. Am I moving too quickly, or am I okay? Can they respond to me? No, they can't respond to me. Okay, I'll move on. Then the next type of business entity that will come about is, I think, one which is very, very popularly used, especially for founders. So for founders, when you're setting up a company, you generally want a separate legal entity to be set up. Like in the LLP situation, you set up a company called private limited companies. So private limited companies are named as companies limited by shares. So what are shares? Shares are things you can trade in, right? So for example, if I'm a shareholder of a company, I can actually put in money to buy this amount of shares. And when I buy this amount of shares, I become a shareholder of the company. I can also become a director of the company. So these entities are quite well known to all of us. If I ever wanted to exit the company, then using these shares, I can actually sell my shares to exit the company for a profit. So it becomes like an investment. In those other models that we talked about earlier, the LLP, the LP, the partnership, and the sole proprietorship models, actually there was no such ability. for us to be able to sell shares. So if you wanted to sell, you want to sell business. So it becomes a bit more cumbersome in relation to how we deal with it. So for companies limited by shares, the good thing is you have shares. And then at the same time, there is full shield against liabilities. So if our SP Lighting was actually SP Lighting Private Limited, and Edgar once again was a person who was negligent and caused a lot of loss to people who bought the lights, what happens is those people can only sue the private limited company. So they can only sue the new entity that has been set up, that has formed a perfect shield against liability for its owners. So even though we are the owners of the company, and even though Edgar was like solely responsible for making all these things badly, he still won't be personally liable because he has set up a private limited company. And if this person whose face has been blown up wants to sue the private limited company, they can only sue for as much as the private limited company has. If the private limited company has only $1 in its bank account, if they want to sue the private limited company and the private limited company only has that $1, unfortunately, you can only have the option of either trying to see whether they have any other assets they want to sell. Otherwise, you cannot actually touch the shareholders of the company who are actually limited in liability totally, as opposed to what happens in an LLP situation. So that's a company limited by shares. This is all very brief. If you have any questions later, please feel free to ask. I can see like 10 questions already beaming up. Okay, so now the next kind of entity that we want to use is, I think, getting more popular in Singapore because Singapore has done very well in the non-profit area. So for non-profit companies, a lot of the times you set up a limited liability company so that you can shield your members from liability. But at the same time, there are no shares because if you're non-profit, you cannot sell shares, right? If you're non-profit, then there are no shares to sell. I mean, you're not making profit. So basically what happens is these are companies limited by guarantee, which means every member will guarantee that if the company gets into trouble, I will maybe guarantee $1,000 or $100. And that's the limit of my liability as a member. If my guarantee is only for $100, then I will only pay $100 if the company gets in trouble. That's it. So companies limited by guarantee, remember, are by nature non-profit companies. If they are non-profit, like companies like MIS, for example, these would be non-profit companies which don't have the ability to trade in their own shares to make money. And shareholders or members, in this case, don't get to share dividends when the company makes money. So that's the difference between the different types of business entities. You might want to choose one entity which suits you best, but you need to then take into account two main considerations. One is, what is your personal liability when you choose this particular model? Of course, setting up a company is much more expensive than registering a business. But if you pay, the difference is about like $300 over as opposed to like $60. So if you pay a bit more, like $240 more for some peace of mind in relation to having a private limited company, I don't see why not. So some people are very penny wise, pound foolish. So must think about that a bit. The penny wise, pound foolish thing also extends to as far as sometimes you don't even want to look for lawyers to set up like proper entities, or they don't want to look for lawyers to like set up properly agreements within them. So if you don't have a proper agreement between your founders, you can also get into a lot of trouble later. A lot of people go into founders kind of arrangement to set up a company, and they're like, oh, brother, like brother, sister, like no one will screw around with you and everything will be okay. But actually, most times it's these brother situations that get you into a lot of trouble. So the best thing to do after you have set up a company or set up any type of entity for doing your business is to then go into like, okay, what are the terms of our marriage? So what exactly are we going to do if things go right? And how are we going to share the money? Who are the people who are responsible for everything that happens within the company? And alternatively, and further from that, what happens, if the company does badly and we have to close down? So if we do have to close down the company, what are the things that we need to share or distribute upon closure? What are some of the things that we need to consider when a company closes down? And companies close down all the time, but some of them might be very acrimonious. Some of them may be very amicable. But generally, I think you have a very good agreement to dictate and govern how the companies how the parties will work amongst themselves if the company closes down. I think that will give a lot of people a sense of ease. So go approach your lawyer and make sure you have a good founders agreement. So next, we then need to talk about my little pet subject, which is intellectual property. So sometimes you don't have to be the best product. How many of you actually think that McDonald's serves the best food in the world? Okay, that's no response because I cannot get a response. But not many people will think that McDonald's serves the best food in the world, I think. If you don't think that, then why is McDonald's doing so well? I think McDonald's is doing very well because of the strength of its intellectual property. So a lot of brands in Singapore actually thrive on the fact that they may not serve the best products, but they give people a very good idea of what they are about. And when people see this brand, immediately go like, oh, it should be safe. So whenever I go to like maybe countries which are not so well known for their hygiene, I at least will go in and eat McDonald's or KFC, because I know that at least internationally, there's a standard of safety or hygiene that's imposed upon each of the franchisees to make sure that everything that at least is served there, I hope, is generally okay. So when we take these things for granted, you know, that when we step into like a Toast box, when we step into a Starbucks, we kind of always know what will be presented to us there. And we know that it has a particular stamp of quality or stamp of standards which we are used to. So a lot of young people now, they would maybe go into a shop that sells clothing, and which is going to be like maybe 100 times more expensive than a shop that sells clothing just opposite it. Even though the manufacturers could be entirely the same manufacturers in some kind of, in Shenzhen or some factory in Guangdong. So it might be the same people who are manufacturing these things, but because the strength of the brand is such that it connotes that, oh, if I buy from Emporio Armani, it'll be very different from when I buy from a brand who is more mass like Bossini, right? So even though both are like legitimate, I mean, they clothe you, but you go to a place which is so much more expensive because you think it exudes a particular goodwill that actually resonates with who you are, and then it aligns with your personal brand. I think a lot of people now think about personal branding a lot, especially in Singapore. But all of these will only come into effect if you take care of your intellectual property. So your intellectual property consists of a few types of IP. Intellectual property is abbreviated usually to IP, right? So, okay, a lot of people will come to me and say, Sam, can I please copyright my trademark? Then I'll go like, huh? Copyright and trademarks are two different types of intellectual property. You cannot like, oh, can I copyright my trademark? 是不一样的. I mean that those are different things. So what is a copyright? Today, we will go through at least this. So next time when you at least come and speak to any lawyers, you have some kind of basic knowledge as to what is a copyright and what's a trademark and how they are different. Okay, copyrights protect four main types of works. So an author or a creator can come up with different types. And these things I'm really passionate about, because last time when I was young, I used to sing a lot, and I used to sing and I used to love music, and I used to actually have a lot of songs that I could sing. And all these are matters which have copyright in them. So copyright is covering four main types of creative works that people can come up with. So if you are a writer, then you are protected by literary copyright. Literary copyright protects anything that you write down, other than like things which, for example, if you draw something on a ruler, then of course you cannot, because those have function. So copyright protects literary works. If you are a photography expert or you are a hobbyist and you like to take photographs, paintings, sculptures, engravings, all of these things are protected by something called artistic copyright. So artistic copyright are things which are drawn or things which are taken like photographs, and things which entail some kind of artistic input for their creation. And then number three would be musical copyright. So musical copyright, we all know what music is, even though nowadays, I think, because I'm quite old already, when we used to have music, used to be very clear melodies, and the melodies used to like, oh, people can sing along. Then that was the proof that it was a good song, that people could actually sing along with you, and they can remember the melody after just hearing it for the first time. But nowadays, a lot of music actually don't seem to have very much melody. A lot of rap, for example, music or hip hop music, sometimes they don't go into melodies as much, but they have very strong beats. So these beats, these melodies, all these things are musical copyright. So in a song, for example, like Home, recently I've been listening to Kit Chan in her many, many permutations of singing Home. So Home has lyrics and it has the melody. The melody is protected as musical copyright and the lyrics are protected as literary copyrights. They could be owned by two separate people. But in the case of Home, both of them are owned by Dick Lee, except for the Chinese lyrics, which are owned by someone else because Dick cannot write Chinese. Okay, then the last type of copyright that we need to talk about briefly, other than artistic, musical, and literary copyrights, would be the copyright in things which you, so we've talked about things that you can sing, which are the musical copyrights. We've talked about artistic copyrights in things that you create, the engravings, the sculptures, the photographs, and we talked about literary copyright. The final type of copyright, can you guess what it is? It is dramatic copyright. So dramatic copyrights are things which are in scripts, things which are in screenplays. So the things that you watch on Netflix now. Now everyone's stuck at home, so everyone just Netflix and chill a lot. So when you Netflix, a lot of the scripts are covered by dramatic copyright. So the scripts in plays and in screenplays, all of these are covered by dramatic copyright. So the four types of works that people can create, once again, are dramatic copyright, musical copyright, literary copyright, and artistic copyright. So there are four types of copyright. So which type are you actually into, and what do you actually create? Then it will fall into these different types. For copyright, you don't have to register copyright, and so it's very cheap and easy type of intellectual property. You don't have to register. The moment you create something, like these slides, which I've created, they're as easy as peasy, right? But for these slides, they also have literary copyright in them. If someone takes a photograph of these slides, then you would actually be reproducing my copyright, and that would be wrong. Okay, so copyright gives to the copyright owner the right to stop other people from copying his works, from performing his works. So copyright subsists automatically. A lot of people will use the C symbol to assert copyright in their works, but you actually don't have to do that. But it's a good practice because then people will know who you are. So if you want to use the copyright notice properly, this is what you need to put in. So you need to put in the C symbol, which is the copyright symbol universally. Then you put in the name of the person who owns the copyright. And then the third element is the year in which the work was created. So for example, you can put in the C copyright symbol, SP Lights, and then 2020, which was the year in which it was created. But if you started creating, if you look at Google, for example, they'll go like 2016 to 2020. If this thing was created from a long time ago, but it's still continually being adapted and upgraded, then you can put in the scope of the years. Trademarks are different from copyright because copyright doesn't protect names, because it knows that trademarks protects names. So some of the most, I suppose, famous trademarks and valuable trademarks in the world now are trademarks like Google, Microsoft, McDonald's. So these are trademarks. So trademarks are things which serve to give you the right to own a particular sign or symbol which you use in the course of your trade. So a particular sign or symbol used in the course of trade sounds very abstract, but what exactly it means would be, for example, if you think of Nike, you will think of a few things. When I think of Nike, I will think of the word Nike, that's one. I will think of the Nike swoosh, which is the tick that they have. And then I will also think of their slogan, which is called Just Do It. So if you have the name, you have the swoosh, and you have Just Do It, all three, the moment you see it, you kind of know that, oh, it's from Nike. So these are badges of origin. These are giving you a sign that, oh, I see this, I know where it's from. So if anyone uses these elements, it becomes like an infringement of trademark because it confuses me. I don't know, how come this one also has a swoosh? Is that a Nike brand? When someone, if you file your trademark and you have a registered trademark, it lasts for 10 years, by the way. If you have it, and someone else uses it in the meantime, then you can sue them for trademarks infringement. And our trademark laws are actually quite tight. So every time someone infringes your trademark, you can sue for up to $10,000 in statutory damages or more if you can actually prove that you have suffered even more than that. So that's trademarks in brief. What do you think are some of the valuable trademarks in Singapore? From what I read the last time, the most valuable trademark in Singapore is Singapore Airlines. Okay, so Singapore Airlines is the most valuable trademark in Singapore because anytime anyone around the world kind of thinks of Singapore Airlines, it knows what to expect. Okay, now patents. The next one is patents, which deals with a total different area of the law. So a patent or patent, some of them pronounce it that way. A patent is something that actually governs your inventions. So if you looked at your phone, the way the phone works, so now there are all these like different ways of opening up the phone, right? Last time it used to be like you have to put in your numbers, then after a while it became like your thumbprint or any fingerprint, and then after a while you just have to show your face and then it recognizes your face and then it opens up the phone. Now, but wearing a mask, of course, like defeats all of that. Now I can't even wear a mask and open up my phone anymore. So the patent to allow people to open up their phones, for example, is an invention which can be patentable. That means it is something which is a step above the state of the art, which gives you the right to say that, mine is better than what has been done previously, and it's a step above, so therefore I can file a patent for it. But patents, once again, you need to file for it. It's not like copyright, which is automatic. So trademarks for 10 years, patents can last for 20 years. Okay, then after that, they are not renewable anymore. For trademarks, every 10 years, if you remember to pay your renewal fees, you can get your trademarks essentially forever, unless you have become somehow descriptive of the goods. So for example, some trademarks that you think about, Pampers. My mother, for example, will always go like, Pampers, like Young Pampers, like that. But Pampers has become almost something that is used to describe diapers. But diapers can have many different types of brands, right? But people would just call them Pampers. If that happens, and if that word has adopted a descriptive meaning rather than as a badge of origin, then it could be possible that your trademarks cannot be renewed anymore. But generally, trademarks are renewable after every 10 years. Patents are 20 years and then done. You can't renew them any further. Registered designs are the way your phone looks, the way that is designed, the different looks of the phone. Those aesthetic elements are covered by registered designs. So registered designs can last for a maximum of 15 years. Okay, so these are the four main types of rights conferred by statute. So for copyright, by statute means we have a Copyright Act. Trademarks means we have a Trademarks Act. Patents means we have a Patents Act. And registered designs means we have a Registered Designs Act. Because I think I'm running a bit behind time and I have a lot to talk about later when it comes to contracts. So I think I'll move on. For passing off and law of confidence, I think they are also very important. So let me go in brief only in relation to the law of confidence. Sometimes when you hire employees, a lot of the things that you want to share with your employees are necessarily confidential. Confidential meaning you don't want them to share with these information or use this information when they leave the company. So for example, if you hire an employee and then you give the employee the entire list of your clients for them to like maybe come up with like a Excel spreadsheet of all your clients or some other like fancy smancy kind of software to where you put in all your clients. When you give this information to them, it was for the stated purpose of having them create this list for you. However, the danger of giving the employee this information is that even after they leave, they can take this information and run with them. So what do you do with that? This is where the law of confidence will come in. So how do you trigger the law of confidence? Well, the best thing that you can do is to have, of course, an agreement with them. A lot of people's employment agreements, sad to say, and it's with utmost respect, very bad. You know, you have very, very bad employment agreements. And I've seen employment agreements in Singapore, which are governed by the laws of Buffalo, New York. And because they steal it from like some kind of online source, right? And then They don't bother to even change the law. So the law is Buffalo, New York. So if you actually want to sue your employee, you're going to sue in Buffalo. I mean, first of all, the name of the place is a bit strange. But then in these kinds of incidences, like, it really impacts the business because you cannot actually take action very much if things go wrong because your clauses of your contract just don't really apply or they're not enforceable. So in these kinds of instances, I think a bit must go and look for lawyer lah, I think, so you get your agreements in place. But if you don't have proper agreements in place, all employees are implied to have a spirit or duty of fidelity and loyalty to their company. I cannot talk too much about it today because I have 10 minutes left. But then I think I will be giving a course, right? So when I do give a course for MIS, please come and listen in. I think these general kind of information will be very, very helpful to you. Now, I need to move to basic contract principles. Basic contract principles, everything that we do every day when we go out is actually governed by contract. How many of you take MRT to work? Or we take a taxi or take a Grab? All of these means of public transport. How many of you have Facebook? All of these means that we communicate all have terms and conditions in them, and you kind of know it, you just didn't care. So when you sign up for Facebook, there was this really long agreement that you needed to go like yes, 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 yes to. All of you will go yes, 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 but the fact is most of us don't actually read it. I did, but most people actually don't read the contract. And when you take an MRT, where's the contract? When you look at your MRT card, right, you turn it to the back, terms and conditions will apply. And they will sometimes even tell you where the terms and conditions are found on a particular URL address. You may or may not go and read it, but whether you read it or not, they brought your attention to it, you are taken to have understood it. So contracts apply everywhere. From the moment we wake up and check your phone, you have a deal with the person who sold you the phone, you have a deal with the telecommunications company that provides for your Wi-Fi and provides for the different services of communications that you have actually paid for. So contracts abound, but it is startling how few people actually know the basics of contract. Some of you have gone to attend some courses where you know some contract law, but actually really how do contracts come into place? I think that is something that we need to really now have some basic knowledge about. So the first thing is, how is a contract formed? Are contracts in Singapore really only valid and enforceable when there's a signed agreement? No. Okay, so in Singapore, you don't need to have a signed agreement for a contract to have formed. So last time when I was younger, I would make sure that someone would take me to school every day because I was quite lazy. It was quite close. I could actually walk to school, but I always make my parents wake up or my sister wake up and fetch me to school, even though it was very early in the morning. But was that a contract? If my father or my mother or my sister refused to send me to school on a particular day, can I then say, oh, you breached the contract and I can sue you for an amount of money? If you went to buy a lamp from SP Lighting and it blew up in your face, is that something you can claim under contract? If there was a contract to say that this is actually something which would have to be reasonably safe, would that be a contract that you can then say, yes, I can sue on? Yeah. You see, there are different types of contracts or covenants that we come into on a daily basis when we go out. But which are the ones that we can sue for? You can only sue for contracts if 4 things actually exist. Okay, so these are the 4 elements. You must remember it with all your mental capabilities to next time know whether you can actually sue someone or whether any valid and enforceable agreement comes to place. The first overriding principle is an intention to create legal relationships. So when you want to sue someone, like in my father's situation, did he intend to create a legal relationship with me when he promised to take me to work or take me to school every day? No, right? But because clearly it was a family arrangement. If it was within a family arrangement, you generally don't sue, right? Because it was out, the consideration, if anything, was out of love and affection. It wasn't something that I can claim and say, oh, don't fetch me to work, I sue you. It was when I was a younger person and I was a rebel, I think I would say a lot of this kind of crap, but none of it actually applies. So if there was no intention to create legal relations, you generally can't sue, right? But if it was within a work environment and within a commercial environment, when someone says something, the general presumption is that there was an intention to create legal relations. Because in a work scenario, no one will talk this kind of like nonsense if they didn't really actually think that this kind of things are things that they wanted to be bound by. So must be very, very careful. Everything you say within the commercial environment, there's a presumption that there's an intention by you to create legal relations. Okay, so other than the intention to create legal relations, we have three other considerations. One is whether there was a valid offer. Secondly, whether there was an acceptance of that offer. And thirdly, it's this very strange concept called consideration. Let's talk about offer and acceptance first. So when we go to Bangkok and we want to buy, this is where offer and acceptance is very, very heavily in play. We just never seen it like that. So let's say you go to a shop in Bangkok that sells this kind of like, okay, like that kind of gao sai or the kind of cookies, you know. I can't believe I said that. Okay, but if there was all these desserts that you were buying, and then you will go to this person, you go like, oh, how much? Kao rai, right? And they will say, oh, 200 baht. You're gonna,太贵了. Oh, why am I speaking Mandarin? I'll go like, no, that's too. So her offer to me was 200 baht. And then I didn't accept the offer because I said it's too expensive. So I said, no, rejected the offer. The moment I reject the offer is killed. That means a rejection, the offer is like very shy like that. So the moment you say no to the offer immediately dies. So I cannot go back. So let's say then what happens is this. Then I go back to all these other stalls that were selling the particular dessert that I was looking for. And then all of them were selling it at 250 baht. Then I went like, oh, actually, that was a very good deal that she's giving me in the first place. So when I went back, then I'll go back there and then I will say, hey, can I get it for 200 baht, the way that you said it earlier? Cannot, you know, because then I would be the one making the offer and she was entitled to either accept or not accept. By the time she had wisened up and realized that everyone else was selling it at 250 baht or above, then she'll go like, no, I can only sell it at 250 baht. So at that case, I cannot like, oh, wow. Just now you offer like 200. Now when you offer at 250, I want to sue you. There was a contract. No, because what happened was she made an offer, you rejected the offer was killed. So if the offer is killed, then when you say 200 to her, you are basically raising your own offer, which is like entitled to either accept or reject. So if she rejects your offer, there goes your gao sai, right? So no more. And then the third part of the agreement is the element of consideration. Some people are arguing that consideration is really not a concept that needs to be in modern contracts anymore, but it still is. It hasn't been taken away. So the concept of consideration is some kind of compromise, some kind of payment or benefit to the other party. So, for example, if she sells me at 250, I pay her the 250 baht. The payment of the 250 baht would be the consideration that would make the whole thing valid. Okay, number two, it's important to know that when you sign a contract with someone else, you have privity of contract with that someone else, meaning you can only sue that someone. So if you, let's say, I play the piano. So if I want to give classes to a child, but the person who signed the contract with me is the mother, then I only have a contract with the mother. So the person who can sue me is the mother. Simple, just privity of contract. So if it's your point that you want, and a lot of people, because they are private limited companies, they'll go like, okay, I use a private limited company to sign an agreement with you. If anything goes wrong, I'll just run away because the private limited company has no money anyway. Okay, that's not very ethical and perhaps not very legal. But they will use that to try to like screw around with you to make sure that you don't get very much. Then in that case, if you really want to also hit the main founder or the person who is within the agreement, then maybe you can do it in the form of a personal guarantee within the contract. How do you go about doing that? Go and look for your lawyer. Okay, then what is exactly in the terms of the contract? So sometimes, you know, when you go out to Parkway Parade, which is a place I frequent, if you go to Parkway Parade and you're driving in and you want to go into the park and you see outside there's all this like very clear terms and conditions, you really will like stand there and like go and read or not. When you're in your car, then the cars behind you will probably bang you to death, right? But no one does that. But why is it that they put terms outside of the car park rather than inside when you go in? Because terms of contract need to actually be added within the contract before the contract is accepted. So when they are making an offer to you, they make the offer to you on the basis of these terms. If the offer didn't include these terms, then when you accept, what are you accepting? So the terms of the contract must be very clearly offered to you at the very start. And then if you don't read, it's your pasar. But if you sign the contract, you are bound to it. But if after you have signed the agreement, they hope to introduce new terms to it, which you had never agreed to before the agreement was completed, then it doesn't come into the contract at all. And then part 4 is how do contracts end. A lot of times, for example, if you have an employee who comes and he states down that he used to work as a pilot in Singapore Airlines, or he used to be maybe the CEO of a big company, when actual fact, he never was all these things. And when you hired him, you suddenly realize that, actually very, very different from what you told me that you are capable of doing. So when that happens, and you find out that what he has told you was actually wrong, then clearly there was some kind of misrepresentation on the part of the person. Or you enter into an investment agreement where someone tells you that, oh, you enter into this investment agreement, sure, we'll make money, and I'll give you like 20% per annum in relation to your money that you put in. So along the line, if people are telling you that you get 20%, first of all, you must like red flag lah, because these kind of things, when sometimes it's too good to be true, it sounds too good to be true, it probably is too good to be true. So when these kinds of things happen and there's misrepresentation, what happens? Or if someone like puts a knife to your throat and forces you to sign something, then what happens? When those things happen, can you say that the contracts were never valid in the first place? Perhaps. But how do we go about doing that? I think there have been a lot of case law about like the tourist guide who actually made this old lady sign an agreement, and all these things can be unraveled if it turns out that these agreements were illegally entered into. Another thing I need to also say is a lot of employers will put in their employment agreements a clause that says that after you leave them, for example, for a period of like 2-3 years, they cannot work in a competitive company. Are those clauses valid and enforceable? Depending on whether you're an employer or employee, fortunately or unfortunately, these clauses are generally illegal and are not enforceable. So if they're illegal and not enforceable, why do people still have it in? Because they think you're stupid. Because they think you'll just sign it anyway and you'll just be afraid of them because 我是老板, so you'll be very afraid. So I think a lot of people will put in that kind of clauses still. But that's why I think that's why knowledge of the law is very important to help you to try to sift your way on what is proper and what is improper when it comes to your employment contracts and the other contracts you enter into. Remedies, what do you sue people for if anything happens? I think these are things which we will talk about in more detail when we know, because it's 1:30 now. I think I will leave some space for the question and answers. Roger, are you there?
Hi, Samuel. I'm here. Okay. Wow, I was actually telling your assistant over there, it's okay, please go ahead, because you know why? I think really, I think from what you have said, we have gained quite a fair bit of understanding in terms of the legal framework in Singapore and what we can work and how we can work within the legal framework. Okay, let's go on to the Q&A now. We've got the questions coming from Mr. Raymond. Both questions, in fact. Let me address the first one. From what he's hearing now, LLP, limited by guarantee, I think LLP, right, can be sued, and the partner can be sued as well if he's negligent. However, doesn't that mean from legal process standpoint, he can also sue the rest of the partners? The rest of the partners can, of course, prove that they are not negligent, but would that also mean that the other partners may be involved in the earlier stages of the lawsuit? But that would mean that the other partners may be involved in the earlier stage of the lawsuit. So what is your take on this, Sam?
This LLP, is it? He's talking about LLP.
Correct, he's talking about LLP.
Okay, in an LLP situation, I think that's why legal cases are never going to be very, very straightforward, because a lot of times, a lot of evidence will have to come in as to like who was responsible, who was not responsible, because the LLP situation is a partial shield, it's not a full shield, right? So practically, when it comes on the ground, when these kinds of cases happen, although the theory is clear, like if you are not responsible, you're not responsible, then you are limited in your liability. But in many, many situations, many people will claim that they are not responsible. Many people will claim that this other person was responsible and try to garner evidence to prove that. So I think the best case is to always have a private limited company. You will still have matters of liability later, but I think generally, try to choose a private limited entity because it's a lot clearer. LLPs, yes, you can do it, but I don't see why it would be something that I would recommend. So the private limited at least would, in relation to third parties, you have a full shield of liability. For the LLP situation, yes, I realize that the laws are not perfect and they really depend upon a lot of your evidence that you can prove. So those are things I suppose will have to come into consideration. But it's true, LLP is not great, and it's not great in all circumstances, especially when there are disputes between the parties. But whenever there are disputes between the parties, it's always not great anyway. Anyone's going to bring other people down with them. So I think, first of all, if you have an agreement that clearly stipulates who is responsible for what, that would actually go some way in mitigating some of the damage that you face.
Okay, great. Sam, perhaps questions from my side. I think before you get straight into a legal suit, there's always other ways in terms of addressing the breach of perhaps the contracts or whatsoever. So there are some legal platforms like the mitigations platforms. So what are the mitigations platforms that are made available to us in Singapore or even at the international platform?
Yeah, I think especially in this age of COVID, right? I think the fact that communication is key between parties is become more clear. That if there were any like cash flow issues that anyone had, I think even the law says maybe the first thing to do is to go and talk to that person and see how you all can actually resolve these matters amicably between yourselves without the need to have to like clog up the courts with so many cases. As Singapore grows in affluence, I think it also grows in litigious people who want to sue for a lot of things. That's I mean, that's quite like bad in terms of resources which are put into suits. I think people have lost the art of being able to negotiate with each other. I think negotiations should always be the first platform that people go and seek. The other platforms which are available other than going to court to sue, firstly would be mediation, as you have said earlier. The Singapore Mediation Centre has actually a very good record of clearing out suits and being able to like let people reach amicable resolution in relation to their disputes. I think so mediation is something that you can try. So what happens in mediation is you go in and then there'll be a mediator who will then sit down and try to get you all to resolve the matter peacefully by signing a settlement agreement. So I think the mediation model, perhaps I've seen mediation where people come out and slap each other, and then like I just got you into mediation just to like get you into the room so I can slap you. You know, that kind of stuff. Like I've seen that, but most mediations that are not so dramatic, and they usually end up with a settlement agreement signed between the parties, and then everyone goes away not happy, but at least with the possibility of being able to like face each other next time in the future without so much awkwardness. The next form of like dispute resolution is arbitration. So arbitration is like a court proceeding in that the arbitrator is able to actually enforce a judgment upon the parties. The difference between going to court and arbitration is that when you go to court, it's a judge. And the judge may not be someone who is very well versed in the type of services or goods that you all are trading in. So he may be speaking from a very objective view, but he will need to have to be told by a lot of expert witnesses how the environment is in relation to these industries, because he's not personally familiar. But for an arbitration proceeding, you can actually look for an arbitrator who is very skilled within your industry. Perhaps like a Zhanglao, an elder within the specific industry you are in, and who is able to give a judgment which is perhaps more in line with what the industry would have come up with if it had an objective viewpoint of what happens. Arbitration is also litigation in that it's not so much, it's not so public, because litigation, whatever comes out, will go into the public view. It can be picked up by the newspapers, but arbitration proceedings can be very, very private, and no one needs to know that they're even happening. But when all these things fail, then we still have the good old going to court. But going to court, as I suppose some of you know, is quite expensive, and it's also very public. So some of the considerations that you may have would be to choose a form of dispute resolution within your agreement when you're signing the agreement, so that both parties are bound to use that particular dispute resolution measure rather than to just everything go to court.
True. I think, Sam, I think besides the cost itself, it's also the stress that you have to go through waiting for the court proceeding. So arbitration and mediation is certainly a better platform, right? It can take you like a year, right, to actually to have the court proceedings even after you have filed. Correct?
Sometimes longer, yeah.
Yeah. Okay, Sam, which brings me to another point. Sorry, I think we do have two questions on from the attendees. Must the payment bracket considerations be in the form of money? Can it be I pay you with assets that I own or I have? Let's say if I offer the payment in terms of my old Hewlett Packard notebook, can I do that?
Yes, you can give consideration as long as the consideration is real. It doesn't have to be of value. So, for example, if you are a parent of a person who owes a lot of money to this person, to this creditor, so let's say you are the parent of the debtor, you can say, okay, in consideration of you not suing my child, I will guarantee the loan. So the consideration can be as nebulous, as abstract as that. As long as it's real, it is okay.
So it can be also in the form of service, all right, in exchange for consideration. Thank you. Okay, next will be by Mr. Andy. All right, which states, I think his question goes as, are we able to insert or exercise such clause even though it is not in the contract? If not, then what other clause or argument we can use or mirror to minimize losses or void of contract?
Sorry,
I know. I'm trying to understand. Andy, maybe perhaps you would like to clarify when you said insert or exercise such clause. You are referring to which clause?
What clause?
Oh, yeah. So maybe Andy, can you help me with that? Just clarify which clause or what clause you're talking about. Let's address the next questions while waiting for Andy to actually clarify on that matter itself. Okay, Samuel. Now we always say that, especially when it comes to employment contracts, there are a lot of clauses that are written there that are a bit ambiguous or even in your own words illegal. But what about in what ways can we protect the current company in terms of employing someone that that has a lot of like what is it, sensitive information besides the confidentiality clause itself, to prevent them from joining a competitive company and yet able to provide what he has learned in your company itself as a form of service, as a form of negotiation. So is there any way that an employer can actually sort of protect themselves against this?
Okay, so there are a few ways you can protect yourself. The first is, I think, key, which people don't generally use. So a lot of people like to say, if you leave me, then within 2 years, 3 years, you cannot go and work for other people within a competitive area. People used to be afraid of that, but now people know that these kinds of clauses, if they are too long in their scope or too wide in their scope, then they are illegal and unenforceable because you cannot prove that you have any proprietary interest that extends so far, right? So a few things, okay, I'll just talk about three. The first is you must, when you are signing the employment agreement, you must be very clear about what is confidential and what is not. right? Because you cannot say that everything that you're exposed to is necessarily confidential, because the name of your boss, for example, you're exposed to when you come in. I mean, that's not necessarily confidential unless you work for Charlie's Angels, Charlie. But in that instance, then that's a very different situation. But if you are working for someone, you must list down what are the confidential things that this person cannot share after he leaves. And these kinds of confidential clauses should be stated within the agreement to survive termination of the agreement. So post termination of the agreement, these kinds of confidentiality clauses would still have to bind the employee. I think that's important. Then number two is sometimes, because this person may not have the full scope of everything, he might want to like maybe hire other people within your organization who have this information. Together they can piece it together and become a real competitor to the company. So you can have clauses that say that you cannot, for a period of how long after you leave my employment, you cannot then go and hire other people within my organization. You can state that. I think that's quite okay. But the last one, which is the one that people usually just bank all their energies on, but which is the thing that they really shouldn't bank all their energies on, is the restrictive covenant, to say that after you leave me, for how long you cannot work for other people. Case law is very clear that if you want to be able to come up with that kind of restriction, you must be able to stand in front of the court and prove to the court that you have this level of proprietary interest in this person, and that if he really leaves and does this to you, then you will suffer this loss, this loss. If you cannot prove, you cannot just across the board say, oh, everyone after you leave me, 2 years you cannot work for anyone in that field. Then the person jia cao, you know. Really. If this person is hired as a script writer, and then if he only know how to write scripts, then you don't make him write scripts, then he really do what? So for 2 and 3 years, he basically just doesn't do anything, man, also cannot. I mean, we are not that kind of economy that would support someone who doesn't work for so long. So you must be very reasonable in your geographical scope. You must be very reasonable in relation to the timing of like how long the restriction will be. And you must be very reasonable on like otherwise the scope, and make sure that it's reasonable not only between you and your employee, but reasonable in the bigger picture of whether it fits into Singapore's public policy.
Okay, so in other words, be very specific in the things that you think should be within the confidentiality clause.
So I tell you honestly, employment agreements are not as easy as people like phrase them generally.
True.
You need to think about it.
True, very true. That's why we need a very acclaimed lawyer like you to help us. Okay, I think Andy has actually addressed that. It's actually the force majeure clause. He said, are they able to actually insert such or exercise such clause even though it is not within the contract? If not, what other clause or argument they can use to mirror or minimize loss or void of contract? It's referring to the force majeure.
Okay, so in this COVID-19 day and age, right, a lot of people are trying to say whether the pandemic has affected things so badly that it can maybe allow them to either terminate the agreement or that they have entered into, or allow them to like delay payments or delay obligations. Yes, so a lot of people are depending upon two main things. One is the force majeure clause. One is the COVID-19 temporary measures, which is the government has come up with. So in relation to force majeure, within an agreement, if your force majeure clause doesn't include pandemics and includes riots and all these things, then pandemics are not covered. That means it's not within. Some people's agreements don't even have force majeure clauses. Some people's agreements have force majeure clauses which don't include pandemics. Both are problems for you now, because if you don't have that clause, you cannot imply it within the contract. It's not something that you can okay, even though it's not there verbally, I can try to imply it in. Cannot. So what you can depend on is the doctrine of frustration. Frustration is not like everything. Frustration is actually a legal term which says that, let's say I have an agreement with Roger, you, for me to sell you my iPhone. But then the day before I was supposed to like deliver the iPhone to you, it got burnt. So then the object of our sale has gone away. Then this entire transaction has been frustrated. it's been frustrated because it is impossible to wait anymore, right? It's not doable. So I cannot perform my obligations because of a cause which I was not directly involved in. So for example, the fire was caused by some accident and it wasn't caused by me. As long as it wasn't caused by me and it wasn't within my control, you can trigger frustration. But whether or not the agreement has been frustrated is something that we need to look at very carefully. Some people have tried to say that, oh, I have a tenancy for 3 years, but because for 2 months, like May, for 2 months, April and May, I cannot actually work. So even though it's a 3-year contract, I think my tenancy with you has been frustrated. I don't think so, because it hasn't taken away the ability for you to perform your other obligations within the agreement. Hey, 2 months out of 36 months is negligible. So I don't think that is frustration, and the cases have said as much that it's not frustration, right? So another thing that you can now bank on is the COVID-19 Temporary Measures Act that the law has come up with to help mitigate some of the cash flow issues that I think our businesses now face. There are 7 types of agreements which are covered by the COVID-19 Temporary Measures Act. You can go and read about it, because I don't think we can talk so long, right? So you can go and read, because the COVID-19 Temporary Measures Act, and which are the agreements that they include and what you can do. Because if you're within the type of like 7 agreements, 7 types of contracts that the act actually refers to, you can actually take out a notification for relief. That means you can go to the website, apply for notification of relief to your landlords to say, use your SingPass, and then say, I cannot pay because of COVID-19. Then for that 6-month or 12-month period, your landlord or whoever's on the other side cannot force you to pay and cannot take out certain legal actions against you.
But can they vacate you out of their current premise? They can't even vacate you.
They cannot. Yeah,
Wow.
For the period of 6 to 12 months. So it's a very, very powerful act.
So if you can't pay your rent and yet they can't vacate you, are you allowed to continue your operations within the?
You cannot be evicted if the obligation that the tenancy agreement was signed before 25th of March, and the obligation to pay was from 1st February 2020 onwards.
Wow, that's something quite interesting, very powerful indeed. Okay, Samuel, I think there's the last questions from the panel itself. Hi, Samuel. For a CLG, a not-for-profit CLG.
Company limited by guarantee.
Okay, right. Company limited by guarantee. Is it compulsory to have members if the plan is to have 3 founding directors to start the charity?
You need to have members. So you need to have members and you need to have directors. It's almost like a private limited company. You need shareholders and you need directors. The question is very good, because a lot of people are very confused as to like the differences between members and directors within the CLG kind of environment. But you must make sure that your members and your directors don't overlap by more than half if you're planning to become a charity, because you need at least 3 charity trustees, right? If you want to apply for a charity. So if you have 3 charity trustees, these are your directors. So these 3 people are your directors. Then you must have members also. So let's say you have 1 member and then you have 3 directors, then that would be okay. That 1 member is generally okay, right? But let's say you have 3 members and these 3 members are exactly these 3 directors cannot. There needs to be a division of powers. So if you have 3 members, then these 3 members can be directors, but then you need another 3 directors to also counter them. So in that way, you need to have at least 6 directors before you can have a proper CLG environment.
Okay, great. I think, well, time check now, it's 1:50. We've gone beyond our time. Thanks, Samuel. Thanks so much. I think, thank you so much. I think you really deserve a round of applause from us. Thank you. Okay. Well, it's a really lively Q&A sessions, like I said, and really on behalf of the community, the business community, and the marketing community, and on behalf of MIS, I would like to give Samuel a big thanks for sharing so much with us. Okay. In fact, if you want to hear more from Samuel itself, please come. You want to learn more from Samuel. Samuel, it's currently It's our newly acquired law trainer from the Marketing Institute of Singapore. So please look out for more of his courses coming up. All right. So if you need more info, do get on to our website or on our Facebook. Look out for Samuel's course. I think Samuel's is going to come up with, I think, more than 10 over short courses on the legal framework on how you can actually protect yourself. Okay, so including contract laws, including quite a fair bit. So do look out for Samuel. If you can't find, please look out for our executive development courses. Executives and our managers over there will be more than willing and more than happy to help you. All right. Okay. Next. Now, of course, during this period of time, MIS has actually come up with the initiative to keep you company during your lunchtime. Okay. So don't leave. The attendees, please stay on. Now, this will be the suite of our upcoming second series of lunchtime webinars. Of course, we'll go on to the third and fourth series. All right. So as for now, you can see the next in line. Tomorrow, we'll be having Mr. Ivan Wong. He's actually a very well-known trainer in the area of digital marketing. All right. And I think tomorrow he'll be touching on the topic on measure what matters online. Okay, I think it's probably looking at analytics and things like that, things that you can really measure while you're doing your digital marketing. So please join us. Ivan is someone that I will really want to learn. I've spoken to Ivan on numerous occasions, and he's someone that really, by talking to him, you know that how equipped you are when it comes to digital marketing sphere. All right, so Ivan is really a very well-known digital marketing trainer. So please come on board. If you miss out on tomorrow's sessions, I really don't know what to say, right? Okay, then of course, I think the series itself, can you flashback on the previous screen, please? The previous one on the suite of speakers coming on board. Yes, now after Ivan, we will have someone from Indonesia, Iwan Setawan, Mr. Iwan Setawan, Pak Iwan Setawan. He'll be touching on marketing 4.0. Now, Iwan is someone that has co-authored with Professor Philip Kotler on a couple of books. One in particular is actually, or a couple of them in particular, Marketing 3.0 and Marketing 4.0. And I understand from Professor Kotler that they're currently working on their Marketing 5.0 together, co-authored together with Mr. Hamawan Attojaya. All right. So now Iwan actually worked for Marketplace in Indonesia, which is a very well-known agency. All right, and at the same time, he will be coming on board to actually speak to us from Indonesia. Do look out for him. Okay, I think I've learned quite a fair bit from him. Now, I've always heard some of the marketers out there. So what is there to learn? What else other than digital marketing? What are the latest and new strategies that you are able to use for marketing? And here is where you are able to hear from Iwan. Iwan actually graduated from Kenlock's University. Okay, all right. So sorry, Ivan will be on Friday, on the 11th. Okay, on the 11th itself of May. All right. Forgot we have a holiday coming, right? Okay. Nevertheless, next in line will be Mr. Eden Ang. Get back to my previous screen. Thank you. Okay, Mr. Eden Ang, I think he's good in actually creating online content. On an average, Eden has got about more than 400,000 to 500,000 followers on his YouTube channel. Okay, and Eden is great in terms of creating content. All right, so he's also our newly acquired trainer. Will be coming on board to teach a series of courses on how to create content. All right, so do hear from him on the 12th of May. And of course, our very, Miss Cecilia Sim, that has been a trainer with MIS for a long time. And she's very, she'll be touching on proactively getting into the selling action, all right, on sales. And last but not least, on this series, second series, will be Mr. P. Subramaniam. Mr. P. Subramaniam is actually a very well-known marketeer. He was a chief marketing officer for one of the telecommunication in Singapore itself, and he'll be touching on building brands through customers experience, which will be happening on the 14th of May. So all this is going to happen during the lunchtime, 12:30 p.m. Okay, All right, so do join us. Now, next. Okay. Okay, like I'll be appealing to all of you again. Please help us in our mask donation. I personally will be bearing the cost of transport to Philippines to help to ensure that all these masks are being handed over to our partner, the Philippine Marketing Association, in actually distributing the masks to all the needies, the underprivileged community in Philippines or around within Philippines itself. So, and a portion of that will be given to the frontliner. So all this will be tracked, will be traced. So don't worry about where it will be landing. We will certainly let you know where does all this mask go. So do join us. It's just $20 for a box of masks, right? So this is the time that you can actually show share your kindness with our community from the ASEAN. So do look out for the telephone numbers over there, Ms. Judy Ko and Mr. Egel. So contact them, all right, to see how you can join us in this mass donation drive. Okay, last but not least, I believe I do have a slide. Yes, do like us on Facebook, all right? Click on the like button and then please help us to actually populate our sessions. Now, like what I've said, if you have missed out on the past 11 sessions, including seminars today, all 12 sessions, you can always find them on our YouTube channels and on our Facebook page, okay? So, and then do like us and then hopefully, you can help us to actually promote our Facebook out there among all your peers. So we have reached the end of today's sessions. So sorry, it actually stretches longer than usual. So do join us tomorrow again for our sessions. And then I hope to see you, all of you tomorrow, right? See you.